Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled The Far from Halcyon Isle Maritime Liens, Renvoi and Conflicts of Law. So this is the last part of the video. The judicial comprised preeminent commercial law lords whose opinion may be considered to be sound both in principle and its reasoning. Lord Reid explained, following that Lord Atkin had held in international trustee, that the selections of the proper law should be approached on the basis of the court ascertain objectively what was the party's intention. In a passage approved first J with the bomb brick. But where the English rule that intention is the test applies, and where there is an express statement by the parties of their intention to select the law of the contract, it is difficult to see what qualifications are possible, provided the intentions expressed is bona fide and legal, and provided there is no reason for avoiding the choice of the ground of public policy. In a mineral shipping corporation v. Kuwait Insurance and Co., Lord Diplock discussed the English rule in a dispute involving the liens as chief forms of maritime insurance policy that was in a schedule to the Marine Insurance Act 1906. UK. He asserted as a comment, without citations of authority, that under English conflict rules, the proper law of a contract consisted the substantive law of the country which the parties have chosen as that by which their mutually legally enforceable rights are to be ascertained, but excluding renvoi, whether of remissions of transmissions that the court of the country might themselves apply in the matter were litigated before them. That comment was clearly an arbitrary dictum, since their lordships held that the governing law in that case was English. Lord Roskill, Brandon of Oakbrook, and Bridgman agreed with Lord Diplock's reason for his ultimate conclusion. However, with characteristic thoughtfulness, Lord Wilbur first discussed how he considered an English court would have approached the questions if the proper law were that of Kuwait. He said, "There is nothing usual in a situation where, under the proper law of a contract, resort is had to some other system of law for purpose of interpretation. In that case, the other system becomes a source of the law upon which the proper law may draw. Such is frequently the case where a given system of law has not yet developed rules and principles in relation to an activity which has become current, or where another system has formed experience built up a coherent and tested structure, as, for example, in banking, insurance, on admiralty law, or where countries exist with a common legal heritage, such as the common law or the French legal system. In such a case, the proper law is not applying a conflict rule, but merely importing a foreign product for domestic rule. Earlier, Jenkins, Romer, and Wilmer LGG also expressed the view in obiter dicta that had it been necessary to decide the point, they would have been disposed to hold the principle of renvoi found no place in the law of contracts. They observed that in consequence, while common law was the governing law, that comprises only its domestic law and excludes its conflict of law rules. In expressing that view, they relied on criticism in this conflict of laws. End of Mr. H.C. Morris and Dr. Chiser in their article of the contrary view of Privy Council in Vita Food. The Mr. Morris, to whom the Lord Justice referred, became the distinguished editor of the 7 and later editions of DC. The article by him and Dr. Chiser was launched by Lord Collins of Mesbury in this biographical note to the 5th editions of DC. In their article, Mr. Morris and Dr. Chazier asserted that the Privy Council had completely failed to appreciate the purpose of the proper law in expressing its opinion in Vita Food, and said the functions of the proper law is to govern the essential validity and interpretations of the contract. They declaimed their lordship use of the contract of laws rules of the governing law, saying that it was novel and unsound. The current editions of DC, Morris and Collins adopted another complementary description of the Privy Council decisions as a lapsus calami. However, it is important to remember what Kumo and Heine J.J. observed in Nelson, that Dr. Morris and his successors as editors of DC has exhibited a marked antipathy to renvoi. The source of Lord Diplock's assertions in Amin Rashid is probably what was in the 10th editions of DC and Morris. Subsequently, Lord Collins and Lawrence Collins J. in Method's Jr. unsurprisingly given these positions as general editor. That DC and Morris advocate that in all but exceptional cases the theoretical and practical difficulties of applying renvoi outweigh any supposed advantages it may possess. He cited in Obiter Dicta with approval that the doctrine of renvoi had not been applied in contrast or the commercial situation. It has often been criticized, and it's probably right to describe it as largely discredited. It owes its origin to a laudable endeavor to ensure that like cases should be decided alike wherever they are decided, but it should now be recognized that this cannot be achieved by judicial mental gymnastics but only by international convention. Another English text, Chaser, North and Fawcett, Private International Law, contains the criticism that no sane businessman or his lawyers would choose the application of renvoi. However, Professor Adrian Briggs have a statutory answer to that criticism in this article in praise and defense of renvoi, that whilst the unsupervised administrations of a dose of renvoi may be capable of upsetting the sensible intentions of commercial men, principal use of the technique may be the only way of giving effect to them. Yet the present state of English law is that this is simply not possible. Prof. Briggs was criticizing an earlier version of the Rome of the Private International Law Act 1995, UK, that substantively abolished renvoi in general law. So this is the end of the article. Bye bye And don't forget to like, comment, and subscribe. Bye.